My name is Emma Hodson, and I serve as the attorney for the Pitt County Board of Education. This training covers school staff members' obligations to report abuse, sexual abuse, and sex trafficking. My goals in this training are to help you better understand the dual reporting system in North Carolina and help you receive 2 hours of training on human trafficking and child sex abuse in any academic year that begins with an even number. Although the state of North Carolina has not mandated this training for NC pre-K staff, the district requires staff in our pre-K program to participate because they have similar reporting obligations to staff serving students in grades K through 12. To receive the 2 hours of training, you should complete 2 trainings created by Safe Schools that address human trafficking, child abuse, and child sexual abuse, and this presentation, which we are also distributing via Safe Schools. You will be expected to complete all required assessments on the Safe Schools platform connected to the 3 trainings. You must also read Pitt County Board of Education Policy 4240/7312 and certify via Safe Schools that you have done so. Pitt County Board of Education Policy 4240/7312 and the slides for today's presentation are available to staff on the district's V Drive. The primary focus of today's presentation is on our role as mandatory reporters. At the conclusion of this presentation, we have some resources that can further support your understanding of this topic and also help support our students. I know that the topic we are addressing is difficult. Some of you may find the subject matter overwhelming and think that there is little you can do, and some of you may just find this topic to be very upsetting. Some of you may have personally experienced abuse or know someone who has. Some of you may have had past experience where you reported something but felt that the report was not handled well. Whatever past experiences you may have had, please recognize that you have gained certain perspectives in those experiences. Moving forward, I ask you to consider your perspective and to continue to make reports to law enforcement and the Department of Social Services. If you find any portion of this training upsetting, please take a break and consider talking through any concerns you may have with your direct supervisor. You should also feel free to access confidential counseling resources provided through our Employee Assistance Program. Ultimately, my goal is to encourage you all to be prepared to make the necessary reports to the Department of Social Services, law enforcement, and in a few cases, the North Carolina Department of Health and Human Services. And together, I hope that our entire district will stay motivated and vigilant in our ongoing work to educate and advocate for the 24,000 students we serve. From the prior Safe Schools trainings, you should have a broad understanding of the concepts of child abuse, child sexual abuse, and human trafficking. You should also have an understanding as to risk factors for child abuse, child sexual abuse, and human trafficking, and know how to identify when a student may be experiencing any of these forms of harm. From a legal perspective, the broader concepts of child abuse, child sexual abuse, and human trafficking are codified as crimes in a number of specific statutes. The good news is these statutes track the training you have received from Safe Schools, so we will not be going through the specific details of each statute. However, we are going to discuss North Carolina law a bit because it provides the why behind some of our reporting obligations. Ultimately, if you recognize that a student is experiencing harm triggered by behavior that falls into the more broad definitions of child abuse, child sexual abuse, or human trafficking, we want you to rely on your broader understanding and make a report. Please do not worry about legal nuance in this context. In North Carolina, any person who is 18 years of age or older is required to report child abuse, neglect, dependency, or maltreatment to both the Department of Social Services and law enforcement. In some cases, school staff, especially those who work in our NC Pre-K programs, may also be required to make a report to the Division of Child Development and Early Education within the North Carolina Department of Health and Human Services. The statutes that govern reports to the Department of Social Services versus reports to law enforcement are distinct, but they also overlap to a high degree. While mandatory reports to DSS have been required for many years, North Carolina law was recently changed to require mandatory reports to law enforcement. The statute requiring a report to law enforcement states that any person who is 18 years of age or older must make an immediate report to law enforcement if the person knows or should reasonably know that any child under the age of 18 has been or is the victim of a violent offense, a sexually violent offense, an attempt, solicitation, or conspiracy to commit a violent offense or sexually violent offense, aiding or abetting the commission of a violent offense or sexually violent offense, or misdemeanor child abuse. The mandate to us requires us to make a report to law enforcement if we know or should reasonably know that a student or another child under the age of 18 is a victim of certain crimes. If you have reason to suspect that a child is a victim of a crime, you should go ahead and make a report to law enforcement. Delaying a report puts the child at greater risk of harm. It is not necessary to investigate further, and attempts on our part to investigate could actually cause more harm. This is because our attempts at investigation can cause psychological harm. Law enforcement and DSS have investigators who are trained to help our students and other children navigate issues that are a major source of trauma. They are also trained to avoid detection by perpetrators of crimes when they are investigating a matter, which also helps to keep children safe from further harm. We are going to go over specifically what must be reported to law enforcement. But again, I do not want you to get bogged down in legal technicalities. One of the offenses that we must report to law enforcement is a violent offense. A violent offense includes both serious bodily injury and serious physical injury. Serious bodily injury is defined as an injury that creates a substantial risk of death or that causes serious permanent disfigurement, coma, a permanent or protracted condition that causes extreme pain, or permanent or protracted loss or impairment of the function of any bodily member or organ, or that results in prolonged hospitalization. Serious physical injury is defined as an injury that causes great pain and suffering and could include mental injury. The definition of a sexually violent offense under North Carolina law, contains a very long list of criminal statutes, all of which involve different types of sexual maltreatment. Rather than get into every single offense, we are going to focus on broad categories. These include contact-based sexual acts, including rape, sexual offense, fondling, statutory rape, and incest. While many contact-based sexual offenses specifically cover minor students, it is also a crime for school staff to engage in sexual activity with a student of any age, including students who are 18 years of age or older. Ultimately, these contact-based sexual offenses are considered sexually violent offenses that must be reported to law enforcement. Additionally, by law, sexually violent offenses include non-contact-based offenses like human trafficking and sexual servitude, indecent exposure, exposure to pornography, forcing a child to provide an adult with entertainment or recording them in various states of undress, and other immoral, improper, indecent, lewd, or lascivious sexual behavior that is willfully taken or attempted against a child. If you are in doubt about whether conduct is a sexually violent offense, we recommend that you go ahead and report what you know to law enforcement. As a final comment, if you are listening to this presentation in 2021, you will see in Board Policy 4240/7312 that the definition of sexual offense is interpreted to mean inappropriate sexual contact with a child. The interpretation and policy should not be read to mean contact-based offenses only. A sexually violent offense includes both contact and non-contact-based offenses, and the board is working to update the policy to make it clearer what constitutes a sexual offense. In any year after 2021, you will not need to worry about this final comment, as the policy will have been updated. Criminal law also consequences people who attempt to commit crimes or aid others in the commission of crimes. If you are aware of someone attempting, soliciting, or conspiring to subject a student to a violent offense or sexually violent offense, or you are aware that someone is aiding or abetting others to engage in these crimes against a student or a child under the age of 18, you should report this immediately to law enforcement. It is less likely that we would encounter this in our day-to-day work, but we encourage all staff to stay vigilant. Finally, we are required to report misdemeanor child abuse to law enforcement. Misdemeanor child abuse occurs when a parent or another individual providing care or supervision for a child causes the child to be physically injured by non-accidental means, allows the child to be physically injured by non-accidental means, or places the child in a situation where there is substantial risk of physical injury by non-accidental means. Misdemeanor child abuse is a legal term, and it is distinguishable from the legal definition of child abuse that must be reported to DSS within the North Carolina general statutes. Although the terms are distinguishable, as you will see on the slides following this slide, there is significant overlap between the legal definition of child abuse, where reports to DSS are mandated, and the 4 offenses that we've just discussed that must be reported to law enforcement. Under North Carolina law, any institution or individual who has cause to suspect that any child under the age of 18 is abused, neglected, or dependent, or has died as a result of maltreatment, must make a report to the Department of Social Services. As is the case with law enforcement, we do not have to have absolute knowledge to make a report to DSS. We only need cause to suspect that something is occurring. If you have cause to suspect abuse, neglect, or dependency, you do not need to investigate the matter yourself. You need to go ahead and make a report to DSS. By law, neglect arises where a child under the age of 18 is or has been a victim of human trafficking, abandoned, not provided the necessary medical or remedial care, or lives in an environment that is injurious to the child's welfare. It also arises if the child's parent, guardian, custodian, or caretaker, which in this case means anyone in the home providing care to the child, fails to provide proper care to the child. Dependency arises where a child has no parent, guardian, or custodian responsible for his or her care, or the child's parent is not able to provide for the child's care and supervision and lacks an appropriate child care arrangement. As I noted before, there is significant overlap in what must be reported to law enforcement and what must be reported to DSS. You can see on this slide that child abuse arises where a child is subjected to or put in a position where they are at risk of non-accidental injury, sexual abuse, or subjected to human trafficking in any form. I will also note that while this slide gives you some of the technical legal information, if what you have witnessed or learned of appears to constitute child maltreatment in a broader sense, you need to report what you know to DSS and law enforcement. While we normally think of DSS as being the agency that gets involved when a student has been harmed by someone who lives in their home, they need to be notified of human trafficking, even if the trafficking is perpetrated by someone who is not a relative or who does not live in the home with the child. State law mandates this report because human trafficking is automatically considered a form of abuse or neglect, no matter who perpetrates it, and DSS is obliged to investigate the matter. This obligation to make reports arises for all of our employees, whether they serve students in grades K through 12 or in our pre-K programs. And it even arises for staff who do not work with students. North Carolina law makes everyone over the age of 18 a mandatory reporter. Having said this, there is one special reporting obligation that arises in the context of our NC pre-K program. Because our NC pre-K program is regulated by the Division of Child Development and Early Education within the North Carolina Department of Health and Human Services, staff in our NC pre-K program are required to make a report to DCDEE if a student in the program is maltreated by an NC pre-K employee or dies as a result of maltreatment by an NC pre-K employee. If you are reporting a matter to DSS, law enforcement, or DCDEE, we ask that you also report the matter to the principal of the school that the student attends. Principals will coordinate with our central office staff and the SRO to ensure that the student and school community are protected and will pursue further action if the student has been harmed by another employee, a contractor, or a volunteer. The Board of Education wants us all to report suspected child abuse, child sexual abuse, and human trafficking to law enforcement, DSS, and/or DCDEE. If you are in doubt about reporting a matter, you should resolve that doubt in favor of reporting. There are strong legal protections for anyone who makes a good faith report to DSS, law enforcement, or DCDEE. By contrast, the failure to make a report can result in potential criminal consequences and the loss of our professional licenses. There are also potential employment-related consequences as well, which could go as far as termination. As a quick reference, this chart is intended to help staff understand their reporting obligations. You will have access to these slides via the V Drive at the conclusion of today's presentation. You may be wondering about the mechanics of making a report to DSS, DC, DEE, or law enforcement. Generally speaking, your report will need to include enough information to help DSS, DC, DEE, and/or law enforcement act on the report, and you should be prepared to share what you know. Names, addresses, information about a student's status, especially if they are injured, and what you know about the incident will help DSS, DC, DEE, and law enforcement assess the matter. You can make a report to law enforcement by speaking to the SRO who serves your school or calling an agency directly. DSS and DC, DEE have options for online reporting, and I have also included phone numbers for those agencies on the subsequent slides. The information on these last 3 slides is a list of resources that may be helpful to you if you would like more information about this topic. I will pause at each slide so you can review the resources, and you will have a chance to refer back to these slides via the V Drive after today's presentation. I thank you for your time and attention today. Before completing the assessment at the end of today's presentation, you should review Pitt County Board of Education Policy 4240/7312, which you can find on the Pitt County Schools website and also the V Drive.